sorry. Okay. All righty then. So again, welcome to the webinar on the ins and outs of HB 2004, which is the bill to provide some measure of access to inactive criminal investigative files. The discussion of what eventually became HB 2004 started in the spring of 2020 and carried forward through the 2020 special session, through the FOIA Council study process in 2020, and then eventually into the 2021 legislative session. The bill was carried by Delegate Chris Hurst, a former TV reporter from Blacksburg, and I can report from firsthand observations that he worked super hard on this bill to accommodate as many competing voices as he could. And as luck would have it, we have the delegate with us here today. And so I'd like to turn it over to him before we go any further to ask Delegate Hurst sort of why he wanted to bring this bill and what he hopes it will accomplish.
Hey, thanks, Megan. I really appreciate the opportunity to be with all of you here this afternoon. I had to chuckle when Megan tried to compliment me there, saying we tried to accommodate many different stakeholders, and there were a lot, and there were a lot of competing ideas and opinions on it. And so I thought it was really important for me to try and figure out a way to compromise where we could while still ultimately achieving the goal of increased transparency, and also making sure that the public really feels like they have ownership of the processes and systems that are part of our state and local government. That ultimately, while I really value what our law enforcement does to investigate crimes and to solve crimes, that their actions are allowed because the communities want them to do their job, but that ultimately their work is public work. And so their work file should be a public file. And so that's kind of the basic fundamental value that I have on why I think criminal investigative files should be required to be released to the public, save for a few exceptions. And so we did, the actual flip. We changed the policy in the Commonwealth of Virginia for the first time to say that there is a presumption that these completed criminal investigative files, these cases that are no longer active, that they would be required to be released. We decided to adopt close to the federal standard for limitations on that requirement for disclosure, to include things like not revealing the name of confidential informants or sources, making sure that we protect rights to privacy and unwarranted invasions of privacy, and those things are included in the bill. What it basically will do now is allow for case files that either are recent or are old, but are finished, they are no longer active, to be accessed by any citizen of the Commonwealth. And we want to also not only try and achieve those basic value statements that I said earlier, but to also look at some things that I think the public really has a strong desire of trying to learn more about, and to examine with the possibility of maybe changing the way things are currently done, to try and make sure that we are not discriminated against any individuals, and that we're actually achieving justice for all people in Virginia, not just certain people in certain cases. And so we want to make sure that unsolved cases have the opportunity of having some examination to allow for maybe breaks in the case to occur and for those crimes to be solved. We want to make sure that officer-involved shootings, that those criminal investigative files have a chance for there to be public review, so that the community can really be bought into the relationship that we have with law enforcement. I think if we want to try and ameliorate that relationship, especially in difficult communities, we have to make sure that the public feels like they have been able to buy in with appropriate information given back to them on the way that they are actually being policed in their own communities. And then also looking at those rare, but those actual examples where we have folks that are wrongfully incarcerated, and how are those cases able to be identified and then addressed. A lot of times it's by having a separate third-party review of those case files. In Virginia, without that ability, prior to, it was very difficult for a lot of advocacy groups to do exoneration work in the Commonwealth of Virginia. This is a sea change moment. This is major reform. And so I'm very sensitive to that, and knowing that those custodian of records are going to be faced with some new challenges. So we did include funding in the budget, both to state police and to the Office of Attorney General, to help facilitate what may be an increase in case file requests as the law goes into effect on July 1st. But I want to make it clear that while there may be extra duties and tasks that are asked of folks who are those custodian of records, I do not believe that it is a burden, and any extra work that is asked, I think, should also be weighed in balance of the public benefit that those folks are able to provide by the work that they're doing and culling those files and releasing them to the public. So it is, I believe, a service and not a burden to ask our custodians of record to comply with this new law. Hopefully, we will be able to see any potential issues worked out, and my office certainly stands ready to try and address some things that may be borne out with this legislation in the future that we may want to improve on when we come back to session in January. So you have my real earnestness in wanting to make sure that this is a workable new reform that we have. But it's also going to make sure that all stakeholders really want to come to the table and try and work through any potential issues that could come out. We spent many times, as Megan talked about, in the FOIA Council, in General Assembly Committee, and in different private conversations of trying to address all of the potential consequences and impacts of this legislation. I think that we've done a really good job in building those appropriate guardrails. But this is not something for me to just wipe my hands away from and just allow the legislation to percolate in effect. It's something where I definitely want to know how effective or ineffective it is in the future, and work hard to continue to make sure that Virginia is a very robust state when it comes to public transparency and disclosure. So, Megan, I appreciate all of the work that you do in furtherance of that. It is difficult work, including getting resistance from legislators like me, but I feel like we will be able to protect our institutions and make sure that the public buys into our institutions if they really feel like they have a good understanding of what we're doing and how. And we get that through transparency. So I really appreciate the work that VCOG does and the advocacy they were able to lend to get this really important legislation passed in Virginia. So thank you very much, Megan, and I'll pass it back over to you.
Well, great. Thank you so much, Delegate Hurst, for giving us that background and the policy reasons for why this was brought not only this year, but why it's been an idea that's been percolating, as the delegate said, for years. And so before we get into the details of the bill and how it's supposed to apply, I wanted to give you some background of how and why we got here. So, for years, FOIA has said that criminal investigative files, from brand new files to those that are decades old, could be withheld from disclosure at the discretion of the records custodian, meaning police or prosecutors. Now, like just about every other exemption in FOIA, the exemption for criminal investigative files was permissive. It allowed the files to be withheld, but it did not require them to be withheld if someone asked for them under a FOIA request. In practice, though, the exemption was used every single time. The police or prosecutors, they didn't even have to look at the file because their policy was to deny access no matter what. And they were allowed to do that. And there are many other instances across state and local governments where certain types of other records are never released, even though they could be. So there was nothing wrong with what they were doing. But there were two things that were happening that made the blanket routine denial of all criminal investigative files a little harder to swallow over the years. On the one hand, very few exemptions in FOIA refer to a file that contains many different parts. Most of the FOIA exemptions are for one kind of record or one type of record. But the criminal investigative records exemption was for a full file of all kinds of different individual records. So a record that might otherwise be required to be disclosed somewhere else in FOIA could be withheld under this 2.2-3706 simply because it had been placed in the file, in the criminal investigative file. So take, for instance, a photo of an intersection in the middle of a city, just a plain intersection, no cars or people visible, just the signs, highway markings, curbs, and such that anyone could see for themselves and take the same picture. Now, if a citizen requested that photo from, say, a local government through FOIA, it would almost certainly be disclosed. But take that very same photo and put it in the file as part of an investigation into a deadly car crash at that intersection, and it can now be withheld by police or prosecutors as a criminal investigative file. So anything could be, and often was, put into the file, which then meant it couldn't be released. Which brings up the second problem, is that that same photo 20 years later, when the drunk driver served his sentence or maybe even died, that photo could still be withheld from the public as an investigative file. So this total lack of access to files as a whole, as well as the individual parts of the file, meant that victims and their families, defendants and their families, had no control over their own stories. They had no way to understand what had happened, how it happened, or why. And it also meant that researchers, journalists, academics, advocates couldn't flesh out important stories and uncover patterns or exonerate the wrongly accused. And it also meant that we couldn't validate a lot of the admirable work and good, really high quality detective work of law enforcement. Meanwhile, the public, like writ large, was denied a reliable way to oversee and hold accountable a government body that it pays for and entrusts to carry out this really awesome power that can deprive people of liberty and even their lives. So this conversation has been going on for years, and it has included legislative proposals that have been brought by both Democrats and Republicans. But this year, 2021, was the year that it finally changed. The law changed to require police and prosecutors, in a sort of simply stated, to open the file and go through it and determine what must be released and what can still be withheld. As Delegate Hurst said, this is a sea change. It's going to be a huge change, both procedurally and substantively, because we're going from routine denial to a presumption of openness. So you can't deny access to a record unless it's been looked at and evaluated. So how is this supposed to work? Now, again, I'm just saying this is how I see it, and having worked with Delegate Hurst on this bill, I have a pretty good feeling that's how he sees it too. So I'm going to start sharing my screen now, and we will walk through this statute line by line. So this is the website. And as I said, I'll make it live after the webinar. And here we have a line by line breakdown of the text. So first things, first thing is that just housekeeping wise, the text that's here in bright yellow is new language that's being added to FOIA. If you looked at this bill on the legislative information systems, this is what you'd see. You'd see this highlighted yellow that is new language. This red strike through language is stuff that's being taken out of the statute. And then you'll see a few places with these highlighted green. That's my highlights to emphasize a particular point, um, or just a you know something that I've noted over here on in the side panels. And then you'll also see one or two of these um, text surrounded by a yellow circle or square. And that's, again, just to emphasize a particular point. So let's get into this. And we're starting now with section 2.2-3704. This is the part of FOIA that just goes into the procedures of how you make a FOIA request. And here in B4 is where it says, usually FOIA requests must be responded to within 5 working days. And response number B4 says if it's not practically possible to provide a response within the 5 working days, that you can ask for an additional 7 working days. Now, HB 2004 says, or in the case of a request for criminal investigative files pursuant to this section, which is the new section 2.2-3706.1, you now have 60 working days. The agencies were worried about the burden that the new bill would put on them, since they are going to have to go through the case files, and those case files could be, boxes and boxes full of records that would have to be reviewed. On the other hand, 60 days is a lot of time. With weekends and holidays added in, it really amounts to you as a requester about 3 months time from the time you first make your request to when you can expect a response. Of course, there's nothing in the statute that prohibits a response before that 60 working days is up. But at least, one small measure is that it was not the 120 days that a lot of prosecutors were asking for when the bill was going through the General Assembly. So next, we'll go down here to the old, not old, it's still there, but so 2.2-3706. This is existing law. It still exists. It's the way it has existed for, a decade or so. It contains 3 main sections: records that must be released, records that may be released, and records that cannot be released. That's still true under HB 2004. Section A here are the records that are required to be released. Now, all of this red struck through language concerns what's known as criminal incident information, or CII. This is information that law enforcement has to provide about felony arrests. Reporters in particular ask for CII, and they can be given the information right away without having to sit through the usual 5 working day response time. Now, we'll go over CII in a moment, but for now, just don't panic, because just because it's all struck out here, it's not gone. It's just been moved. But because of the way that you have to show a statute to show what's new and what's being, changed, it's all struck through here, and it looks very scary when you see, what do you mean criminal incidents information is being taken away? It's not. It's just being moved. So we'll put a pin in that for now, and so that we can discuss the rest of 3706. So the rest of the information that must be released is still here. It's just been renumbered 2, 3, etc. Now, section B of 3706 is for discretionary releases. These are the records that can be released but do not have to be. So law enforcement has the choice to withhold records under this section, just as they always have. Now, subsection 1 here is what used to allow any and all criminal investigative files to be withheld. It said other than CII, law enforcement didn't have to disclose any of the records in a file, no matter how old the files were or whether the cases were long done and no longer relevant and no harm could result. Now, HB 2004 limits this discretionary release now to those investigations that are ongoing. Now, it doesn't say that explicitly, but when it says not required to be disclosed in accordance with 3706.1, and then you look down at 3706.1 and you look to see that, CII are not, let's see, where is it? Excuse me, that certain files are not ongoing. You'll see that, this, I'm getting confused. I'm having a hard time articulating this because this is one of the reasons why we're having this webinar, is because you have to toggle back and forth between this old section and this new section to realize that the 3706B1, as it exists today and it has existed, still applies to cases that are ongoing. It's just been taken out to say that it's not going to apply to those records we talk about in 3706.1. I wouldn't have drafted it this way, but then I'm not a Division of Legislative Services lawyer, and I'm not sure how this particular construction came to be, but that's what we have right now. So after that, you have the subsections 2 through 11 that are all, the same as they have been. These are types of records that can be withheld at the discretion of the custodian, but can be released if the custodian chooses. Sections C, D, E, and F of 3706 are also the same as they have been. And it's just, worth noting that C here is that section that says that people who've given information on a crime after being promised anonymity, that their information shall not be released, that they shall remain anonymous. It's one of the few places in FOIA, though that number is growing, that does say thou shalt not release this information, and that doesn't change. D here is for non-criminal records. E has to do with 911 calls. And F is a conflict resolution provision that says that FOIA controls over other sections of the Virginia Code that might have to do with disclosure, but only if those sections actually conflict. I mean, if there's no conflict, then the other section still applies. So now we get to the new 3706.1, and it's broken down into sections A through E. Section A here gives us some definitions that will come into play later on in 3706.1. The phrase immediate family refers to a section below about photos depicting a crime victim. It's actually the same language that's used up here in 3706A3, right here, records of completed unattended deaths, meaning deaths by suicide, overdose, or a heart attack, for example. But those records have to be turned over to the victim's immediate family, so long as those family members have been cleared of any participation in the death. So we're using that same definition back down here in 3706.1. The second term that's defined in A here is ongoing. And ongoing refers to cases where the prosecution hasn't been adjudicated, where evidence is still being gathered for future use, and where release of information about that future prosecution could jeopardize the future investigation. So the term is used down here in subsection 2. The last phrase that says not ongoing. So we're going to come back to that in a moment, but here is that definition that we can refer back to up here in A. So for now, though, let's move down to subsection B, which starts out by saying that the following records shall be provided. Just like 3706 above it, you've got required to be released. This is where all that struck through red text from 3706 got moved. Okay, all that is almost word for word from the old 3706, but with 3 important additions. First is the lead-in language here, which used to just say criminal incident information on felony arrests. Now it makes clear that this information should be gathered not just from an officer's memory and jotted down in summary, but it should be taken from notes, reports, and things that are filed through law enforcement's incident-based reporting system, which is largely electronic. It's supposed to be more expansive, a greater pool of information that can be shared. Then the data that is to be extracted from those sources is to include a general description of the crime, the date and time, that's the second addition, the general location of the crime, the identity of the investigating officer, a description of the injuries or property damaged or stolen. And then the third addition to this section is here in little f. And it says that any diagram that may have been created about the crime or the location has to be shared as well. Now, there is an exception here that says that, yeah, but if those diagrams reveal security or vulnerability security vulnerabilities, I got tangled up there, sorry. And that's what this 3705.214 refers to. If the diagram shows those kinds of things, then you can withhold that. But if the diagrams don't show those kinds of things, then they have to be included as part of the criminal incident information release. Finally, this last paragraph here just confirms, this is the same as it was in the previous law, that a verbal response is okay if a reporter asks for CII, that they can be just given a verbal response if they agree to it with law enforcement. So, you with me so far? Yeah, it's dense. So now to subsection B2. Now, again, this is information that must be provided, and this is really the nut of this statute. So it says that criminal investigation files, investigative files that are not ongoing must be released. Now flip back up to A to see the definition of ongoing, to understand for a file to be not ongoing, then the prosecution or the police, then the prosecution has been adjudicated. The investigation does not continue to gather evidence for future use, and release of information would not jeopardize that future use. So that this subsection 2 also then defines what might be in a criminal investigative file. That's the same as it was that it is in the above section when talking about ongoing ongoing cases, excuse me. This list is, I don't know that it's supposed to be exhaustive. It's supposed to be comprehensive. And like I said, it is mostly the same as what has been in use in 3706. So again, these are for the case files that are not ongoing. Okay. So, but what subsection B2 giveth, subsection C taketh away. Now, section C is lifted more or less, as Elliot Hurst mentioned, from the federal FOIA. They have a provision that allows for the release of completed investigations. And it says that even though this says B files must be released, that B doesn't apply when those case files don't have to be released, or a single part doesn't have to be released if one of these 6 harms exist, one or more of these 6 harms. So what are these? So if the release of these files or something in the file that is not ongoing, I'm going to say inactive because this not ongoing means that there's so many double negatives here. But if something in that file would interfere with a particular ongoing investigation, or if it would deprive a person the right to a fair trial or impartial adjudication, if it would constitute an unwarranted invasion of personal privacy, then it doesn't have to be released. If it would disclose the identity of a confidential informant or information that was only provided by that informant, or if it would disclose a law enforcement technique or procedure, if it would endanger the life or physical safety of someone, then the record can be withheld. Now, that does look like a lot of information that can be potentially withheld, but it is important to note some of the limitations on these limitations. Okay. First of all, notice from my exaggerated pronunciation that all of these 6 harms start with the word would. So this isn't speculative. This isn't what might happen, what could happen. This is what would happen. If this, then that. Notice here too, in number 1, that it says the release of the records would interfere with a particular ongoing investigation, not one that might happen in the future. And the example that I want to bring up here comes from, and I'm going to mention again, Connecticut in a minute, but in Connecticut, there was a case where it had to do with Sandy Hook, and someone said that a release of some of this information might jeopardize the future prosecution. And the Connecticut Supreme Court said, who are you going to prosecute? Because the guy who did it is dead. There can't be further prosecution. And so that reason was not allowed as to justify withholding any record in that case. So you have not only, that there's got to be a particular ongoing investigation. It also, in number 1, it has to show that that it would be jeopardized in a particularly identifiable way. It's not just a general, it might get, something might happen. It has to be given, there's got to be a reason for why this case would be compromised. And then down here in 5, when it says, if release would disclose law enforcement techniques and procedures, notice that it also says if the disclosure could reasonably be expected to risk circumvention of the law, meaning that if someone found it out, that they would somehow be able to exploit that and, excuse me, in order to commit another or a future crime. And finally, though, this last phrase here says that these 6 harms shall not be construed to withhold information that's unlikely to cause any of these effects. So, again, we're not just talking about speculation. On the other hand, we do have this number 3 would constitute an unwarranted invasion of personal privacy. I'm not sure what that is going to mean and how that's going to be interpreted. There's a lot of guesswork that's going to be involved there. But overall, I think the clear intent here is that if records are withheld, then there must be some specificity involved in explaining why these records are being withheld. Saying just no is not going to be good enough anymore. So moving into the last parts of the bill, subsection D here makes sure that requests for the data required to be collected and disseminated by section 52-30.2 is still available, even if it could be withheld under this new section. I don't know how it could be, but it's just making sure that it's not going to be. Now, section 52-30.2 was passed in the 2020 regular session and then amended in the special session later that year. And it says that for traffic stops, stop and frisk interactions, and law enforcement other law enforcement interactions, law enforcement is supposed to collect data on the race, ethnicity, gender, whether a person speaks English, the reason for the stop, the location for the stop, whether a warning or citation was issued, or whether there was an arrest and what they were arrested for, if the vehicle was searched, and whether physical force was used by either party. So all of that has to be collected, and this 2.2-3706.1D makes sure that the aggregated and anonymized data will still be released on request. That's the first paragraph of D. The second paragraph of D, and I'm not sure why these two are together instead of in separate sections, but it says that photos, recordings, and video that depict a victim or allows a victim to be easily identified can't be released to anyone except the victim's immediate family. Remember that definition from A. Or if the victim is a minor, if the victim is a minor, then to the victim's parent or guardian. Some important things to note here: that first, this shall not release section does not apply to transcripts of recorded interviews between law enforcement and the victim. That says that right here in the statute. So yeah, any interviews with the victims would not be considered a depiction of the victim. Secondly, it does not serve as a reason to withhold photos up here in criminal incident information. So you know that because this section refers to B2, not B1. It refers to B2, and that is the section that says, case files that are not ongoing. There has been a long-standing practice between law enforcement and the press that has allowed the exchange of photos, particularly, right soon after a crime, to give a human face to a crime. Like the photo of a smiling mother who may have been killed in a car crash with a drunk driver. This section D is not here to prevent that kind of agreement and exchange between law enforcement and media that has existed for a long, long time. But this section is a potentially big loophole. A lot of individual records in a criminal investigative file may depict the victim. But this section exists essentially because of the 2007 shooting at Virginia Tech. Every time the discussion of access to criminal investigative files has come up since then, law enforcement has pointed to Virginia Tech and essentially said that The public should never have access of the photos to that day. During the General Assembly session, I asked that the prohibition be a bit narrower. As I mentioned just now, the Connecticut Public Records Law, after Sandy Hook, they did add an exemption, but it's an exemption and not a prohibition like this Virginia law. And it was only for depictions of homicide victims, not victims of any crime. And it was only to be if the release of the picture was constituted an unreasonable invasion of privacy to the victim or the victim's family. It's also worth noting here that after Sandy Hook, there's actually now a website that has almost all of these investigative files on it, that came out of a study commission that they initiated. There's not an exemption there for closed investigative files, and some sheriffs in that state have actually encouraged the public to come into their offices to look at a whole slew of records on high profile cases. But what we have in Virginia is different, and I'm interested to see how that's going to play out. So this section E makes clear that records that have been put under seal or some other restricted access by a court don't have to be disclosed in response to a request. Now, FOIA already says that records are prohibited from disclosure if another law prohibits them, but in a court order, would be another law. But I guess just trying to be an abundance of caution, that was reiterated here in section E. Now, if you looked at this bill online, it would look longer than this. It would go on for a couple, like 2 or 3 more pages, but actually all that stuff that's left are things where they've just had to change references to code sections and cross references and things like that. There's no other substantive material after this subsection E. So the bill doesn't go quite as far as VCOG wanted it to, but it went farther than law enforcement and prosecutors wanted it to. So, that's the true sausage making process. But I do stand by, and I think you heard Delegate Hurst say that, this legislation is intended to change the status quo. There may be still opportunities for records to be withheld, but it's not acceptable to simply say no without taking a look at the file. And I think, and law enforcement knows this. I mean, they certainly have mentioned it when they have referred to it in the context of other discussions about FOIA, in particular fees. So that's not a surprise to anyone. And but I also know that the best laid plans can go sideways. So I wanted to take a break here for about 5 minutes. And when we return, I wanted to talk about tips and strategies for making requests for records and things to look for when if you're making a request. It's much shorter. That second section is much shorter than this first session. But I hope you will come back at let's say at 2:55. Okay, so thanks, and I'll see you in a little bit. Hello, and welcome back, and thank you for sticking with me. We had a few drop-offs, but we still have quite a few people left, and that's good to know. I had some time to look at a couple of questions that are here, and so before I get into anything further, I can go ahead and try to answer those. So there was a question about whether ongoing refers to, when it says finally adjudicated, how long does that last? Does it include theoretical appeals to the Supreme Court, or is it essentially the end of the original case? As far as I know, in the way that it was described when we would talk about it, it's the end of the line, the last, possible appeal, whether that was at the Supreme Court level or whether it is the state level. It's when the case is nowhere else to go. And it is just about that particular case, that criminal case. It does not have to do with any civil suits that might arise from it later on down the line. There was also a question about whether this bill includes the files from the Department of Forensics. So 3706 applies to those entities, let me see, all public bodies engaged in criminal law enforcement activities. Um, it is not, it's my understanding that the Department of Forensics is not engaged in law enforcement activities. They may provide support, but they also provide support for the Department of Health, for instance. They are not a law enforcement body. I wasn't quite sure what to think about this. So I went on their own website and their own FOIA page where they are supposed to list records that they may typically withhold if requested under FOIA, and there is no mention of criminal investigative files. It has not been my experience that this is a section that that applies to the Department of Forensics. I hope that's right. So and then the final question that popped up was, are record holders required to blur or otherwise remove identifying information in that case? And I think that was referring to subsection D, the photos. Um, I it's I guess they certainly could, I guess, but then I don't think, I mean, if the picture is about the victim, the whole, if it allows the victim to be identified or it depicts that victim, that record is pretty much just exempt, or not just exempt, but that's prohibited from disclosure. I don't see that as any. I don't see that as the usual rules for redaction applying. But it is important to note that redaction rules do still apply. In even under 3706.1, if a record in an old file has someone's social security number on it, those other provisions of Virginia law that say that you can't release, except for the last four, or is it the first five? I can't remember, but then you can't release a whole social security number. That still applies. If there is some sort of medical information about a witness or a victim, there are still exemptions like that are still within the code. Those can be redacted. So it is still, it's important to remember that 3706.1 still exists within the framework of FOIA. So the same FOIA procedures, the same FOIA responsibilities, and the same FOIA exemptions are still there. So I think that seems to be all we have. I'd like then to return to sharing my screen here, so that we can talk about some kind of tips and strategies when using the new 2000 HB 2004. So we're going to go to this section here. Wait, I hope you saw my cute little flow chart. I did that myself. So, some tips and strategies here. First and foremost, plan for the long haul. So, though CII still has to be responded to quickly, the rest of the new 3706 comes with a built-in window that amounts to nearly 3 months. You're not going to get records quickly under this new section, and it's quite possible that there will be a run on requests early on. So there might be a lot of pent up demand, and so don't expect any quick fixes. And since it is going to take a long time, more than we're used to under existing FOIA, it's important, I think, to map out what you're looking for. So, like, what are you hoping to get out of this request? Is it information about a case as a whole, or information about a particular player in a case, a defendant, witness, prosecutor, investigating officer? Are you looking for patterns where multiple requests might be needed? These all require different approaches on how and when to ask for records. So when you do ask for records, be very clear about what cases you're interested in. Don't send your local police department on a wild goose chase for the John Smith case without further identifying which John Smith you're interested in, or when the crime occurred, or what the crime was, or anything else that might help zero in on the exact case file that you want. So narrow your request when possible. You may not need to see the whole case file. If you're interested in just a particular aspect of the case, or again, a particular person, you may be able to limit your request to records, related just to that. Or maybe you just want to see copies of one particular transcript or one particular witness statement. By narrowing your request, hopefully that will reduce the time and cost of that request. Be patient, as noted above, but also be persistent. Keep track of when the request was made and when a response is due and what was said in the back and forth and between you and the government. Did you agree to a response time extension? Did you narrow your request? Did you talk about fees? There may be some hiccups here and there, but FOIA does ask that requesters and government work together. So, work together, be patient, but be persistent. Be aware of the demand, at least for now anyway. Request a cost estimate. Right now, there's no requirement that an estimate or breakdown of costs be given unless the requesters ask for it. So ask for it. So when you know what the expected cost is, then you may want to narrow the scope of your request. And you will be asked to pay, and it may be a lot. So expect that too. Now, law enforcement frequently said during committee hearings on this bill that it was going to cost them a lot to comply, which means it's going to cost requesters a lot because they need to recoup their costs. Now, some of these cases are really big, and there's a lot to go through. The records will need to be segregated into, those that cannot be released, like the victim photos, those that can be withheld under the enumerated harms, and those that may be exempt from other parts of FOIA. And then there are those, what's left over, that must be released. So, but all that segregation and review is time, and time equals money. So just be prepared. And being prepared sometimes means questioning the cost estimate that you've been given. How many hours did they say it will take, and at what rate of pay to review how many records? You know, are those estimates reasonable? That's what the statute says. The statute says reasonable and the actual cost. So even if they are reasonable and the actual cost, you may still want to try to negotiate some part of the estimate, because again, FOIA does encourage requesters and government to work together. And finally, on these tips and strategies, I'd add ask for explanations. As we went over in detail, you know, 2004 says all those harms have to be, they can't be speculative. It's that they would occur. So if you're only told the bare minimum, ask for details. And it's not just to be, you're not doing this, you know, just to be kind of be a smarty pants or anything. It's that if you need to go to court over this, a judge is going to need to see whether the reason that the police or prosecutors have given is well supported, or if what they've given is a conclusory or a speculative reason. So while we're going through this process, then there are a lot of, you know, question marks out there. How is this section going to be interpreted, or what else could come up? So I have this other section over here of what to watch for. And what to watch for would include, let's see, I hope that you can you still see this? Because I have a, um, hmm, um, okay. Anyway, so are you, I'm very sorry, but I have two screens going and one of them just cut out. And so I'm afraid that the rest of you have been cut out too. And so that's what I'm trying to make sure that you haven't been.
I don't think so, Megan. I mean,
Okay.
from what I can tell, I mean, it shows up on my screen. I think everyone else can see it too.
Okay.
It's your checklist of questions.
All right. Thank you, Jeff. Yeah. I do see on my other screen that it does say it's reconnecting. So yeah, I think I just lost that. So, you know, so you've got your plan ready and now you've submitted your request. And so what should you be keeping an eye out for? So, you know, these are points that could help you, you know, with your existing request, with future requests. And they're also, the reason to look out for them is because they might identify places in the statute that need to that we need to come back and address in future legislative sessions. Something may not be working the way that people expected, or that people actually realize, you know, that's not what we had in mind. Here's a new problem that's popped up. But things you need to keep in mind is, are you still being denied files in their entirety? So like, is the whole thing exempt for one reason or another? Or given the intent of the bill, you know, a blanket denial like this will likely be eyed critically. So will denials where every case file is still being called active or ongoing. I don't think anyone thinks that that every case file out there is still some way ongoing. So keep an eye out for whether or not a case is being called ongoing, or all cases are being called ongoing. Of course, some files still will be ongoing, obviously, and for reasons that aren't immediately obvious to you, but you should note that if it's happening routinely, or when exactly it's happening, that language in the statute does nonetheless have to say, you know, what specific case and what kinds of cases, and how is this case how would release of this jeopardize that case, that ongoing case. If you've been denied all or part of a file because of one of those 6 harms, that you've been given, check to see that you've been given substantive information about those harms. Again, I keep harping on this, I'm sorry, but the statute uses the term would for a reason. That was changed specifically so that it didn't say could or might. So you need to be given some kind of detail here to make sure that we're talking about real harm, or, real harm that is likely to occur, that would occur, not might, and that a judge could look at if it came to litigation. If this record's being held in withheld under subsection 1 of those harms, have they identified the particular way in which release of this file or this part of the file could interfere with the investigation of another case? And if the record's being withheld under subsection 3, that unwarranted invasion of privacy, it's good to know whose privacy and why. Since this phrase hasn't been defined, it'll be important to know how it's being interpreted and applied. The victim depiction section would be another example, and another thing to keep an eye out for. Does it seem like every record's being called a depiction of the victim, or is it being used narrowly? As I just mentioned, are more records being filed under seal in ongoing cases? Not just this is important to know for the ongoing cases, is are you seeing an uptick in cases being sealed with the expectation that if they're filed under seal now, that when they are no longer ongoing, that those sealed records won't have to be disclosed under the statute? So keep an eye out for that as well. Figure out just what your cost estimate means. So keep an eye out for things like, what would the final price per record turn out to be? Sometimes it's hard to gauge the fairness, the reasonableness, or any trends when all we're given is just sort of these, lump sum kinds of amounts. So, when you're given an hourly salary, what does that work out to in terms of an annual salary? And if you're given an estimated amount of time, how many hours how many days do those hours add up to? This is just all, part of determining reasonableness, part of determining actual cost, and part of determining the real world impact of the burden on law enforcement and the cost on citizens to obtain records. And finally, which localities or agencies are doing a good job here? Let them know, and let us know too. We want to know who's doing it well, so that they can be models for others who might not be doing it quite as well. And they're going to be both, and we need to know which ones are which, so we don't throw the baby out with the bathwater, but that we also don't paint a picture in the future that says everyone's terrible and this, nobody's using this law the way it's supposed to be. And when I say let us know about that and all these other things, there's this form on here, our HB 2004 feedback form, and you can fill it out. And unfortunately, so after you hit next here, you have to explain what it is. There's information here about the basics, about who you worked with and what kinds of records you asked for, what year the underlying crime took place, just so we can kind of get a sense of like how old, how old are these files that people are looking for. And then the following pages just ask for input, like, what were you told? How long did it take? What was the communication? Who was hard? Were you given specific information? All those things that I just went over under the what to watch for category. There's a space there for you to put your name and your affiliation if you want to, but you don't have to. But this will, again, hopefully, let us figure out what's working and what might need to be fixed. So that does wrap up the presentation part of it. If you're still with me and you haven't passed out yet, I'll look at some of these questions to see if I can get to them, but some of them I might not know the answer. So what's to stop a law enforcement agency from saying, well, one side could still appeal this, so we can't release anything? Well, appeals do have limitations. There's even appeals to the Supreme Court. The only things that don't have really sort of unlimited appeals have to do with habeas corpus and petitions in death penalty cases. But otherwise, appeals generally have a finite end. And you can think about too, I mean, if it's no adjudication, if the person has already served their sentence, which could happen too. But yeah, I mean, I guess that could continue, that could be a problem, but this was looked at by a lot of people who do work with the Innocence Project in particular was very involved in the development of this bill, and they did not seem concerned about these, what if appeals somewhere in the future. So I guess it could be gamed, and that's certainly something to watch out for as well. And sure, Jordan, that's your last question. Jordan, I for anyone else watching, Jordan and I know each other. I wasn't picking on someone just randomly. That's so let's see. Was there any other that got okay, can someone reach out to me later and get a, okay. So that I think covers all the all the substantive questions. I can drop now into the, I guess, into the Q&A. Let me drop the website if you haven't gotten it already. And while I'm doing that, I just want to remind you that this is a free presentation to everyone, but it is not cost free to us. We still have resources and overhead that we need to cover, and we rely on the kindness of friends and strangers. And so if you can, it'd be really great if you can, let's see, if you can support us by giving a donation or by becoming a member. I will put our website here. I just dropped the website address for HB 2004. And if you want to give a donation, that is the website. And if you would like to become a member, that is right here. So again, this has been recorded and I will post it on this HB 2004 website. I'm interested in your feedback. If you want to drop me a line about what you think about this webinar, and if there are some other topics that you might be interested in hearing us go over in the future. But for now, I appreciate your attendance and your attention and your interest in this, and thank you for coming.
Well, thank you, Megan, for hosting this. It's been really, really informative, and I'm sure will benefit a lot of journalists and members of the public. So thank you for putting this together, and those resources are great. So in addition to your posting it on OpenGov VA, I'll put those links both to the video and to the resources that you've compiled on the spjva.org website.
Great.
Cool.
Yeah, thank you. All right.
All right.
Bye-bye.
Thanks. Bye-bye.